Welcome. Today we're talking with Rodrigo Santelices, Principal of Santelices Law, a civil litigation law firm specializing in landlord-tenant law. Rodrigo, welcome.
Hi, James. Thank you for having me.
Rodrigo, a lot of our members rent apartments, houses, etc. And sometimes it's the case where there's a dispute with the landlord and they're faced with the prospect of having to deal with landlord-tenant court. In your experience, what are the best practices for one, avoiding having to go to landlord-tenant court in the first place? And secondly, if you are faced with that, what general advice do you have for someone who, has no other alternative but actually going to landlord-tenant court or is taken to landlord-tenant court?
I think, in a general sense, James, probably the best place to start is when you come to rent an apartment or a house, especially in New York City. You should start first by focusing on your lease and your lease negotiations, being very careful with what you're entering into, because most of the times a dispute is going to arise at the end of your tenancy when you are ready to leave. You've packed up everything, and then your landlord is going to come back to you and say, hey, A, B, C, or D. And it's always, or most of the time, it's going to be based on the lease, because that happens to be a contract. And that's what your landlord most of the times is going to be relying on. And like I said before, it's the source of most of the disputes, right? So that should be your starting point in the beginning, to be very careful that you read. And a lot of people don't realize that when you're entering into a lease, you do have some leeway to negotiate. It's hard to believe that, because when you come, especially again in New York City, it's such a difficult market sometimes, because you want an apartment. There seems to be so much demand for it. You happen to find one. You're dealing with a broker, and there's pressure on you to just sign these contracts so that you can secure the apartment. Many times it happens to so many people. They're just so happy to have landed an apartment. They've agreed on a price. Everything seems fine, and you just quickly read the lease. Everything seems fine, but you don't read it carefully. Number one, you are expected to, number one, read it carefully and point out things that you don't agree with. They could easily be scratched out if you negotiate, if it's something that just shouldn't be there because it's unfair. It happens a lot. And you can take a little bit of time to do that. Once you've done that, there's some things that tend to pop up a lot, say like the issue of fees. People find out at the end of the lease term that the landlord wants to charge them all these fees that they didn't realize were in their lease, because they were in a hurry to secure the apartment, and they've accumulated during the tenancy, and at the end of the lease term, they have a bill to pay, and they either want to take the deposit away from them, or they want them to pay extra money at the end of it. And that's the kind of dispute that can land you in housing court or in small claims court, or really you don't want to be in any court with your landlord at the end of your lease term. So that would be my first advice. First, I know it's difficult. It's difficult for everyone. No one wants to read a long document with very small writing, but it's really important to read your lease and be on the lookout for things like fees. If you're new to New York City, if you're a new Australian, you might hear from people that, broker's fees are illegal. You shouldn't be charged those. That was only a very small window of time. Now, don't be surprised by a 15% of a year's rent as your broker's commission. Application fees, you should be wary of those too, because a broker, besides their commission, will probably want to charge an application fee to file the application with the landlord's management company or whatever. those actually cannot be more than $20. These are small things that here or there they add up. And again, the pressure of time or the pressure that sometimes brokers put on people. There are so many people wanting this apartment. You sign, take it now, or you will lose it. And if you sign, you're going to be without realizing that you could be accruing all these fees. What's another thing that you ought to look out for? Security deposits. Your landlord is never allowed to charge more than 1 month rent for security deposits. There's all sorts of crazy stories happening, especially with small landlords in far-flung places in deep Brooklyn or Queens. Sometimes small landlords will take you aside and give you the old story, you know, I'll just do this for you. I'll charge you less rent, but, you know, I had a terrible tenant before, did terrible damage to the apartment. So now to be safe, I really want 2 months security or 3 months security, whatever it is. The law actually says that they're not allowed to charge you more than 1 month security deposit, okay? And that they need to return it to you within 14 days of the end of your tenancy. Late fees, that's another type of fee that landlords love. But it should be, if it's not in your lease, there should be a specific clause detailing how much the late fee is going to be and when it actually accrues. When is your rent due? It's usually the first day of the month. Is there a grace period? Many times. This is something that you can negotiate. Most landlords, it's common practice that there should be a grace period before you incur a late fee. It's completely normal for people to almost demand a grace period. If your rent's due on the first and you pay on the second, you shouldn't really be accruing immediately a late fee. This is across the board in residential and commercial leases. Late fees usually, I've seen all sorts of things in leases, but there's usually at the very least a 5 to 10 day grace period before the late fee accrues. But again, that should be stipulated in a specific clause in the lease. If it's not in the lease, then they're not entitled to be charging you late fees. If at the end of your tenancy, your landlord says you owe me late fees and they didn't charge them during your tenancy, it's probably because there wasn't a clause in your lease. So be mindful of that. Late fees, again, if there is a clause for a late fee, the law says that it cannot be more than $50. Okay, so the law says that a landlord can charge a late fee of either 5% of the monthly rent or $50, whichever is less. Okay, so in other words, no landlord in New York can charge more than $50 in late fees.
Okay, let's say we're in a situation where there is a dispute over something and someone has to go to landlord-tenant court. You know, what is the process there? I suppose the first thing they have to look at is, well, what is my cost and what is my return? And I'm sure a lot of people are very emotional about this. They feel that they got ripped off and they want to go to court. What are the thought process that a tenant really needs to go through before taking legal action in a matter like this?
So that's, I feel that's a really insightful way to ask the question, James, because you touch on very salient points when it comes to people that are faced with going to court. There's a lot of emotion. There's a feeling of injustice, obviously, that can lead you to make decisions that end up costing you money, because whenever there's a legal dispute in court, unless you're willing to do it on your own, it's going to cost. The housing court is a complex place. There is, maybe not so much now, but there used to be a perception that you could just go and deal with it on your own without an attorney. It's kind of like, you know, small claims court, that sort of thing. Unless you've dealt with courts or have some legal training, I would strongly advise you against doing that. Because it's landlord-tenant law is very complex in New York City, and housing court is an extremely busy place. It's summary proceedings, which means that they move very fast and it's hectic. So you're going to be pressured into agreements that if you don't understand very well, you could end up in a bad place. Number one, try and avoid it. But if you can't, you should know that there's a lot of advice available just with a quick Google search. Personally, I do a free consultation when people reach out. And the way I do my consultations is when people are facing housing court is I try to see how much the person can do on their own, see where the limit of that is, and before they need to engage me or retain me as a lawyer to represent them. Because many people are quite capable of doing the negotiation with the landlords or even the landlord's attorneys to try and solve the dispute. But ultimately, if you have to go in front of a judge or if you have to write legal papers, then yes, you should retain an attorney. And it really depends on what kind of dispute you're facing. Generally, housing court deals with just 3 types of disputes. And ultimately, if you're a residential tenant, there's only 3 types of disputes that you would ever be envisioning going to housing court for. Number 1 is for non-payment. Number 2 is what they call a holdover dispute, which is practically anything that doesn't have to do with paying rent. Your landlord is basically saying, I'm terminating your lease for any other reason that's got nothing to do with paying rent. It could be you being a nuisance, you've broken the rules of the lease, and that gives me the right to terminate your lease. Those type of cases are known generally as holdovers. And the third type of case is what in housing court they call an HP action, and it's something that the tenant initiates when the landlord is failing to do repairs and uphold what's generally known as the warranty of habitability. Going back to your point, is it worth it for you? How much return are you going to have if you decide to fight the case? If you're in housing court because of a non-payment case, in other words, you owe rent and your landlord has taken you to housing court to get that rent from you, you are going to have to pay whatever it is that you owe at the end of the day if you want to stay in the apartment. And it's tricky to go to housing court on a non-payment and fight it. There are reasons that you could fight it. Say, for instance, the most common one that people in non-payment cases decide to fight their case in court is when a landlord has failed to make repairs for a long time. And it happens all the time, unfortunately, in New York City. Even in expensive apartments, where sometimes things structurally go wrong. Windows don't have proper insulation, and there's a draft that just is always there. In winter, there's bad heating, or in summer there's no AC, and people live with that for months on end. Or their neighbors are so terribly noisy and the landlord does nothing about it. And people just get fed up and they stop paying their rent, or they deduct money from the rent, and they end up in housing court for those reasons. And they feel that they should be in some way compensated, or that their rent should be abated, which is the term they will use in housing court. Reduce whatever debt you have to the landlord because of the damages you've sustained, or whatever inconvenience you had during the time, that the period of months that you owe rent. That is the most common dispute that a tenant will have with a landlord in a non-payment case that actually gets litigated in housing court. For that, you will want to have an attorney to represent you, because you're going to need to flesh that out, usually at a trial. And in my experience, it has to be really bad, really bad conditions for you to get, say, a 50% abatement. So say you owe 3 months rent, 4 months rent, for you to get a 50% reduction of that debt, the conditions would have to be terribly bad. And I'm talking mold in the bathroom and, that level of bad. Generally, housing court is not terribly sympathetic to people just dealing with a bad landlord by not paying the rent. If you're working, you don't want to be taking time off work to go to court. But yeah, that's the kind of thing that you would want an attorney to represent you. And again, going back to the turn of your question, it removes you from the emotional aspect of the dispute.
Rodrigo, I know that a lot of lawyers, landlord-tenant lawyers, they see each other on a daily basis. They kind of know each other. They're not adversaries all the time, shall we say. I'm sure they have lunch and drinks after work together. So having that relationship, I'm sure that there are situations where having a real estate lawyer that can sit down across the table from another real estate lawyer, and you take out all the emotion of the landlord and you take out all the emotion of the tenant, that in those types of situations, these matters can be resolved a lot quicker and obviously a lot less expensive, because you don't have this proceedings dragging on and on.
Yes, absolutely. And another benefit of it, James, is, and generally when you take into housing court in New York City, housing courts and for that effect, all court proceedings are public. So any court filing can be found online. So if your name is on a housing court proceeding, they used to be what was generally known as a blacklist, and the infamous blacklist for tenants, because this information could be accessed by future landlords. And if you happen to be on this blacklist, potentially a future landlord would just refuse to rent to you. I mentioned earlier that in 2019, the rent laws were amended. One of the amendments was that this blacklist was outlawed. There's not supposed to be a blacklist anymore. Unfortunately, the changes to the laws take time to be implemented. And I feel that if a landlord wants to find, if you put in an application to rent an apartment, if they want to check your background and see if you've been sued in housing court, they're going to find out, because even if the court is not selling this information anymore, they're still open and public proceedings. So if you are sued under your name, that's going to pop up. If you have an attorney, when you go to housing court, these are some of the things that your attorney can negotiate into an agreement, so that, for instance, usually court papers would carry, say, my landlord is Landlord LLC, and they sue me, would be Landlord LLC plaintiff against Rodrigo Santelice's defendant. An attorney can negotiate to change the caption or before you are sued or after you're sued, so it just reads John Doe or Jane Doe. The court allows that, the law allows that pseudonym to be used instead of your name, which in this particular case can be quite handy.
Rodrigo, we've covered the landlord-tenant scenario, but I hear so many stories, and I'm sure there's thousands of social media posts about a situation where there's a sublet. In other words, a tenant sublets their apartment to you, or you have the situation where it's the tenant might have an extra room and they sublet that room to someone for a short period of time. And what they do is they take a deposit. It might be $600, $1,000, whatever it may be. And what happens then is at the end of the when the lease is up, thanks very much, I've been here 3 months, it's time for me to leave. Here's the receipt for the cleaner, everything is spotless. And then either the roommate or the tenant that's subletting to you refuses to give back to your deposit. I suppose this touches on what we were saying before about, cost versus reward. What options are open to you? There's obviously a lot of emotion associated with this. People want to take them to court. It's the same, but it's a different dynamic because you're not dealing with a landlord, you're dealing with a tenant.
I would start with the same thing I said at the beginning. That there should be an agreement to mark the spot for you. So even if it's there's a difference in scenarios, right? Let's take the subletting scenario first, as opposed to the roommate scenario, because they're different. Let's talk about subletting. For those that are unfamiliar with it, in New York City, tenants have the right to sublet in specific circumstances. Usually in buildings where there's 4 or more units, there's a right to sublet, which is basically you're saying, hey, landlord, I have a lease with you, we have an agreement, but for whatever reason, I have to go to another country or something, I have to be absent from here. And during that time, I'm going to sublet the apartment. I'm going to have another tenant living here. And I'm still responsible for the rent to you. I will continue to pay the rent, but I'm going to have someone else living here. The landlord cannot unreasonably withhold your right to sublet. So that's just a bit of information in case you are in an apartment, you have a lease, and imagine you have to go back to Australia in a hurry for whatever reason, you can sublet. Your landlord cannot unreasonably withhold the permission to sublet, but you should ask. Okay, so let's flip the scenario, and you are subletting like you suggested, James. And at the end of the sublet period, like you mentioned, you're ready to go, and the person you're subletting from gives you a bill. This is what I meant with there should be a document at the beginning. When even though you're subletting, you're still entering into an agreement with that person. So don't fall into the trap of just agreeing that, okay, you're paying $1,000, $1,500 rent. I'm going to pay whatever we agree, and there's nothing written, because then you expose yourself to that person who's subletting from you to just come up with any excuse to say you broke the agreement. And it's not difficult to put an agreement in writing. We're not talking about fancy legal terms or anything like that. An agreement can be written in any language you want, as long as both parties say, this is what we meant, we meant when we wrote it, this is what we agreed to, and they both signed it. It can be handwritten. A court will uphold that as a contract. And it should include things like, when I came in, the apartment looks like this, and when I leave, I'm going to leave it. Usually the word or the term is in room clean condition. No one should expect anything more than that. There should be, in other words, there should be an expectation that there's some wear and tear from people living in the apartment. So you shouldn't be charged extra fees if you left the place in broom clean condition. Landlords are expected or reasonably expected to just return your security deposit if you can show with photos that you take at the end of your tenancy that you left the apartment in broom clean condition. The same thing applies to a sublet situation if you can show that. If you have those photos, if you were, again, strongly encourage you to have documentary evidence of how you left the apartment or how it was when you took it, so that you can make the comparisons. If you're faced with the situation where the person you're subletting from just absolutely refuses to give you back the security that you paid when you started the subletting, I'm afraid you're going to be faced with having to take them to small claims court. In New York City, small claims court is the place where you would go for anything $20,000 and below. A small claims court is actually a place where you can go on your own. It's there are attorneys there, but it's actually designed for people to do it on their own. There's no legalese. There's no the legal jargon has been decreased as much as possible, and it's all forms that people can fill out, and there's no expectation that you'll be writing legal papers or anything. So that is one place where I would say 95% of the population can bring an action, can sue someone to try and recover the deposit in this case. And it's a place where it will move relatively fast, depending on how much money it is and the quality of your evidence, which again brings you back to the suggestion that you document everything really well.
I might be oversimplifying here, but is it like a scene from Judge Judy or something like that?
Yeah, I think I would probably agree a little. It is a little like that. Hopefully, someone not as colorful as Judge Judy, but then again, it is New York City.
So, Rodrigo, I have a roommate that I'm the one that holds the lease with the landlord, and I've rented out a second room to cover my rent. And I need to get rid of this person. They're inviting people over late at night. They're, holding noisy parties, or for whatever reason they need to go. What are my rights in those situations?
Yeah, those tend to be tricky because it's not the same as what we were talking about in terms of the subletter who is taking possession of the whole apartment, and it's easier. Oh, I mean, it sounds crazy, but it's actually easier to get rid of a subletter who's taking over the whole apartment than to get rid of someone who is sharing your space because they're in there. So changing the locks in this situation is not going to necessarily help you because they're still going to have all their possessions inside. I mean, it might help you, but it's an uncomfortable and difficult position to be in. And ultimately, uh, housing court again would be the place for you to go if everything else has failed. Uh, I would recommend, obviously, all sorts of um, tactics before going to housing court. That should always be your last resort because of expense, time, annoyance, and everything else that we've covered. But roommates are tricky, and one of the major annoyances of living in New York City many times because the relationship can become difficult after a while. So if dealing with roommates, in dealing with roommates, the initial advice applies, put it in writing. Absolutely always when you're having people occupy your space, coming to temporarily, whether it's for a long time, whether you're sharing or whether they're taking over the whole apartment, always put it in writing, whatever it is that you're agreeing to, and what the conditions of your agreement is, right? If your roommate is clear that you don't want noise or parties or anything like that, then you have a clear agreement that they're breaching so that you can give them warnings and later try to end the agreement and ask them to move out. Most people tend to do it when you tell them to because no one really wants a change of locks and then having to deal with uh, your property being locked up. It's just unpleasant for everyone, but unfortunately, the situation does come up when people turn really unreasonable. And again, unfortunately, there is no magical solution where if you are, as an Australian, the tenant with the lease, and you take on a roommate, and this person is not who you thought they would be, and they become difficult. Unfortunately, it's not a magic solution to remove them. You have to engage the court.
Rodrigo, let's talk about pets. And this is an interesting scenario that I've heard is that in an apartment building, there are sometimes multiple dogs, and sometimes dogs don't get on with each other. And I've heard a situation where a landlord has a separate lease for the dog. So if they don't like a dog, they can actually evict the dog. The tenant's fine, but the dog's evicted. But in those situations, what happens is that no one's just going to get rid of their dog, so they leave as well. So it's a sort of a strategy on behalf of the landlord to get rid of a tenant with an unruly dog. So is this something you've come across? And secondly, what are the rules about having a pet? Let's say, for example, you've got a lease and then you don't have a pet, and suddenly you feel the need to get man's best friend or woman's best friend. What happens in that scenario, and what are the rules around that?
Well, that's a hilarious story. I hadn't heard of that, but it doesn't surprise me. New York City, and it's actually quite smart to tell you the truth. I admire the ingenuity behind it. But in this sort of situation, um, like I mentioned earlier, the laws changed in 2019, and this is another one of there were major changes in 2019. Up until that point, there was all sorts of litigation as well in housing court, landlords trying to evict people because many buildings are strictly no pets, and it's on your lease. It's no pets clause. There are a lot of leases that specifically say no pets allowed, and the law is now very clear, and the case law also very clear that if you live in a building with a, even if it's absolutely specific and clear that says no pets, however, if you still decide to have a pet in a building like this, and your pet is kept openly for 3 months, then your landlord is out of luck. They cannot sue you or try and evict you because you've kept the pet openly for 3 months. What does openly mean? Again, that's an issue for argument and negotiation, but from the cases, the examples are what you would imagine, taking your pet for a walk, going through the lobby in and out without attempting to hide your dog or whatever pet it is. And most buildings have lobbies cameras, right? So if you've taken, let's assume it's a dog, if you've taken your dog for a walk, it doesn't have to be every day, even during those 3 months, that's going to be sufficient for you to be able to keep the dog. Now, returning to your very funny note at the beginning, just because you're allowed to keep the dog, say this is a no pets building, and you have 2 dogs, and for some reason no one objected to you taking the dogs for a walk in these 3 months, and you're allowed to keep the 2 dogs, but the dogs start making noise and they start barking all the time, or they start barking or fighting with your neighbor's dog, then that's a different story, right? That becomes a noise issue. And then your landlord can now try to evict you and allege that this is a nuisance, that you're breaching the lease because you're causing a nuisance and an annoyance to other tenants. And that is completely allowed.
Depending on the building, like for example, you've got, Miss Jones or Mr. Jones who is retired and doesn't have a lot to do every day, and watching you bring a dog into a building that's no pets. There's a lot of risk involved in this sort of subterfuge, trying to get a pet into a no pet building by sneaking it under the landlord's radar.
You make a very good point, and I would be remiss not to highlight that, James. What I was saying before applies mainly in relation to rental buildings. If you live in a co-op or a condo, for that matter, there's different rules, and that it's not going to help you. The 3 month rule that we were discussing before, because then you're in a co-op, especially you're bound by the bylaws, and there's a co-op board, and it's a different story.
Yeah, and I also know with co-ops, they're very anti-renters in the first place. they do
Yeah,
have some provision for rent, subletting. But if they do that, everyone knows, and they watch the new tenant like a hawk, and
exactly.
and
Exactly.
there's a greater risk, I suppose, for someone in a co-op because you only have a share in the building, you don't actually own your apartment,
Right.
so they can vote you out essentially. So,
Right. And you really want
subletting
to
in
have like
a
value.
co-op brings a whole new set of risks, which is beyond the scope of this conversation today.
Yes.
But Rodrigo, I want to thank you for your time today. You've been very generous with your time. If someone wanted to reach out to you, that they're facing a situation, they'd like to get some legal advice around landlord-tenant court, what is the best way that they can reach you?
The best way to reach me is either on my cell, which is 718-200-2946, or you can just go to my website. All my contact information is there. You can contact me using the contact button, which shoots me an email. That's really the best way to get in touch with me. Like I said before, I do a free consultation where my aim is to see how much, especially in disputes before they get to court, how much of it you can resolve yourself with the information that I can provide you.
Great. Well, what we'll do, Rodrigo, is we'll include all that information in the description below the video so people can just scroll down a little bit. I won't point. You can just scroll down a bit and they'll see
Yeah,
all your contact information in the description. Well,
that's
again,
great.
Rodrigo, thank you again for your time, and we really do appreciate it. Thank you.
It's been great. Thank you very much, James.